Are you a landlord or tenant? Are you looking for a better way to resolve disputes? Hi, I'm Simon Dippenaar and I'm an attorney. Rental housing is a minefield. Tenants and landlords alike ignore the commitments they make in the lease agreement. Tenants stop paying rent, landlords refuse to return deposits. Tenants damage property, landlords unlawfully change locks. The list goes on. Many of these grievances wind up in the eviction court, but eviction is costly for landlords and painful for tenants. There is a better way to resolve landlord-tenant disputes: mediation. Now, mediation is a voluntary alternative dispute resolution process that lets aggrieved parties resolve a dispute in good faith without a formal involvement of the court. Taking the eviction process all the way to court costs a lot of time and money and doesn't always achieve the intended results. In mediation, both parties are willing to consider mutually acceptable solutions in the best interests of the future relationship. Mediation negotiations are private, confidential, and conducted on a without prejudice basis. This means parties can be honest and transparent in their discussions. This is less likely to happen in a high conflict courtroom scenario. In other words, if mediation is unsuccessful, nothing discussed during mediation proceedings can be used against the other party in court. Mediation reduces the time it takes to get a result with less risk and less stress. Until recently, mediation was not compulsory in dispute resolution. However, judges increasingly believe that civil litigation should be avoided where possible, less adversarial and more cooperative, less complex, more certain with shorter timescales, more affordable, predictable, and proportionate. In light of this new approach, changes have been made to the Uniform Rules of Court to make provisions for mediation. Rule 41(a) of the Uniform Rules of Court makes it mandatory to consider mediation when instituting any new action. A skilled negotiator should be involved in any mediation. Potential mediators include a law firm specializing in property law, tenancy agreements, and evictions, like ST Law, or an independent statutory body like the Rental Housing Tribunal. The process of mediation is relatively straightforward and can be done over the telephone or by video conference. The mediator guides the discussion and helps the parties identify the issues and arrive at their own solutions. Once the parties agree, the mediator draws up the terms of settlement in writing. Both parties must comply with the agreement. Provided the parties stick to the terms of the agreement, the dispute is considered settled. If the parties are unable to resolve the dispute or fail to adhere to the agreement, the formal legal process can proceed. Even if mediation is unsuccessful, it is always worth the attempt to avoid the eviction process. I believe residential disputes should be settled as amicably and cost-effectively as possible. Mediation saves time, money, and aggravation. If you need advice on any aspect of rental housing, landlord-tenant relations, or mediation, please give me a call on the number in the signature below.